Janice Irwin, your moderator on today's show, Voices Against Sexual Assault. Matt Zacharewicz is here from Albany County Crime Victim Sexual Violence Center. Hi Matt, how are you?
Very good, glad to be here.
Good. Why don't you tell us what your position is for the crime victim?
At Crime Victims, I'm a victim's advocate, and what I do there is I advocate for victims on behalf of victims to the district attorney, who's the prosecutor in criminal cases.
Oh, wow. I think it's pretty interesting how it came about that you ended up in this position.
Well, yeah, I'm certainly happy to say that I've been with the center for about 3 years. I started out as a volunteer and to get courtroom experience, and from that there happened to be some jobs opening up, so I was able to interview for the position and get the position and pass my civil service exam. It's a long process, but after 3 years I'm there permanent.
Wow, it's pretty cool because we always see the call for volunteers out and about in the media, and here's someone who's volunteered right in front of us, and it's turned into a career for you.
That's true, yes.
That's really great. What was your interest that led you into volunteering at Crime Victims?
Well, I had a background in criminal justice and in alternatives to incarceration, and I wanted to get more experience with the court experience and learning what it's like to be in the court from a defendant's point of view, lawyers' points of view, judges' points of view. And with the volunteer experience, I was able to be right in there and experience it for myself.
Oh, so your interest was always really looking for alternatives rather than incarceration.
That's true,
and
right.
so it started to do research and looking into it more. Oh, it's really interesting. What exactly do you do as an advocate?
As an advocate, a lot of my days, or many days out of the week, I'm in Albany Police Court or other courts throughout the county, and I meet victims there, either who are there for arraignments, preliminary hearings, or other adjournments, which we'll go into a little bit later, or I also meet them through phone contacts. And for the most part, if there's a victim there at court, I'll talk to them on behalf of the district attorney and advocate for them to the district attorney, who's the prosecutor in the case, so that the victims feel a little bit more welcomed and get a little better understanding, so I can spend more time with the victim and other advocates like me, rather than the district attorney, who's obviously very busy dealing with a lot of cases.
I would think this had to be like really specific training that you had as a volunteer. And
that's true, yes, there is specific training. I'm glad you brought that up, because this process that we're going through today is a part of my training. It's for volunteers. It's a training that I've given multiple times, and it's something that I'm glad that I get to also offer today.
If someone did want to volunteer, you want to give a phone number?
Sure. Debbie Ceramic is the volunteer coordinator at Albany County Crime Victim Sexual Violence Center. Her phone number is area code 518-447-5500.
Great, and they can call and find out more about volunteering over there. I know they have a lot of different needs between the hotline and court advocacy.
But I also understand that she's going to be coming here and giving a talk specifically on the volunteers and the volunteer process, so stay tuned to that.
Good. So Matthew, what happened after that? You ended up in this position now, and you actually go with a victim.
Right.
How does that get hooked up? How does the victim hook up with you?
The victim hooks up with me in a lot of different ways. Like I said, they could get the number from the phone book, from a referral agency and other social service agencies. They could just show up in court, and if they tell anybody in court, whether it's a court personnel, a judge, a police officer, a district attorney, they would bring them to my attention, and I would speak to them. I would find out what specifically they're there for, whether it's for an arraignment, adjournment, sentencing, and then I would speak to them and give them more information of what's going on, what's the possibility of what could go on, and then of course give all that information to the district attorney so that they can prosecute the defendant in the appropriate manner, hopefully based on what the victim tells me.
So you're sort of like a liaison between the victim and the DA's office?
Absolutely. Liaison is a great word.
Oh, that's a really great service. What happens after someone calls the police?
When somebody calls the police or after a crime occurs, there's two ways that the victim can get in touch with the police officer or the police station. One is a phone call, or two is actually going to the police station. But if the victim does choose, or complainant in this course, does call the police, the phone call is prioritized. If it's a simple harassment or something very minor happen, it's going to have a low priority. So the police officer is going to have a very slow response to that phone call. However, however, if it's a very serious crime, the police officer will respond much quicker. If it's something in regards to somebody personally being in the house, or a very serious crime like a rape or a very serious assault occurred, their police are going to come with their sirens on and their lights on, are going to get there very quickly. But if the victim can go down to the police station and have that opportunity to do so, that is another way that the victim can also receive a good response from the police.
Would you list some of the crimes that are entailed with you being an advocate?
Some of the crimes would include assault, harassment, criminal mischief, and then of course we're going into the more serious ones like rape and attempted murder, homicide survivors, families of those who've been afflicted by homicide, and those are some of the catch-all phrases for those large groups of crime. But there are also very, in the law book, there's very individual crimes: assault thirds, assault seconds, assault firsts. But we deal with anyone that would consider them a crime, a victim of crime.
Okay. And what if there isn't an arrest for the crime? What if the police haven't been called or no arrest has been made?
Well, if there isn't an arrest that has occurred, the victim could refer to the incident number that was given to them on their standard incident report or their domestic incident report, and those are the forms that are filled out initially. When the victim talks to a police officer, the police fills out these forms, and then there's an incident number. Usually it's 2 numbers followed by 6 numbers, and that follows them throughout the court process and police process. If there's a crime that occurs and there hasn't been an arrest made, the victim can contact the detective's office, and in that refer to that incident number so that the police station can identify which detective has that case, and the detective could give information to the victim, and the victim can give information to the detective about what happened.
Oh, so like where an arrest might not have been made because they can't find the person, or there wasn't enough description of the person, or there was no description, the person remained anonymous or something.
Right.
But the crime was still committed, so they can still then call the detective's office.
Right. And of course, evidence plays an important role in that. When you're talking about evidence, there's some more important types of evidence rather than other types of evidence. But the most important types of evidence are that of the crime scene. But when you're talking about crime victims, you're talking about somebody who's possibly physically attacked. And if it's an assault, the person's body themselves is a crime scene in regards to bruises, lacerations, contusions, or it could be considered, if it's in a sexual assault situation, a forensic rape exam could be administered, which would give specific information, possibly extrapolate even DNA evidence for the detective to go about their investigation.
Wow. After the arrest is made, then the arraignment happens next. Will you tell us about that whole arraignment process? What can someone expect?
Right. The arraignment is the first court appearance for the defendant.
Oh, it is? Okay.
It's a good time for the victim to be there because the victim can speak to the judge, can speak to the district attorney, and also speak to me.
So the victim isn't required to be there, but they are welcome to be there.
Absolutely. Okay. It's a great opportunity for the victim to be there, and they're not always told that they need to be there or should be there.
That's what I was kind of thinking. I didn't realize that the victim would be, it was open for them to be there for the arraignment.
It would make a lot better smoothness through the court system if victims were there at a first appearance, but they're not necessarily always required to be there.
And they could actually speak with the judge.
The judge would want to find out what kind of took place. It would probably be one of the only times the victims could have an open forum to speak to the judge and the district attorney. The importance in speaking to the judge at arraignment is because the judge will decide whether or not to issue an order of protection. The order of protection, there's actually two different types of orders of protection. The first is a no-contact order of protection, which means exactly that. The victim and the defendant cannot have any contact and needs to stay away from the defendant. The importance in that is that if that's the only way that the court system can prevent something occurring from the future in ordering the defendant to stay away from the victim. It's not in the orders of protection that I see, there isn't specific diameters of feet that the defendant needs to stay away from.
Oh, there isn't?
No.
I thought that was commonplace, like, oh, they can't come more than 500 feet or 1,000 feet or something.
Right. No, not in criminal court that I'm familiar with. It's typically it's subjective as stay away, no contact. You can be within 10 feet but not have contact. However, a victim might feel uneasy in that type of situation.
Right.
So sometimes that's where the wording can be difficult. The other type of order of protection is a no illegal order of protection. And that no illegal means that the defendant can have contact with the victim, but the defendant can't be threatening, harassing, or violent. In other words, commit illegal offenses against the victim. This is good for families who can stay in the same house, or if they're not living together and have children in common, that they can exchange their children. But it is, again, protecting the victim from the defendant from becoming threatening, harassing, or violent.
Or maybe like in a work situation, what if they're like co-workers or something and there's an order of protection, then it would be the second one. What's that called again?
No illegal order of protection.
No illegal order, okay.
Right, that's very true. And the order of protection that's given on the arraignment or is a temporary order of protection. And that temporary order of protection is only for a short period of time, or sometimes it's called pending prosecution. And pending prosecution means until the final court date or sentencing.
Oh, so it's not maybe 30 days or 60 days. It's usually until the next court appearance, or
usually next court appearance or the final court appearance. So it could be pending prosecution. There's no date. They don't know when prosecution is going to be finalized, so they just label that there because it could be possibly there might be a final order of protection issued at sentencing, which would be good for X amount of months or years. It's usually subject to how serious the crime was, whether it was an A misdemeanor, D felony, E felony, C felony, et cetera, et cetera.
I would think in some ways if the order of protection doesn't restrict them in feet or have a distance thing, that can be terribly intimidating, and yet the intimidation would be a hard thing to prove. Right.
It's sometimes difficult to prove, back to the evidence that somebody didn't stay away. In large apartment complexes, a victim and defendant might live a couple floors apart, but still have a no-contact order of protection, still could be in an elevator together and not have contact. But if a victim were to say, this person looked me in the eye, came up to me, pushed me up against the wall, and I felt very intimidated, and I was concerned of my safety, that could constitute harassment and violation of the order of protection.
Oh, okay. So I think another instance where they're going to run into each other is in the courthouse.
Well, however, that of course is an order of protection is subject to any other court order.
Okay.
So if the court order is for the victim and defendant to be in the courtroom at the same time, they can be in the courtroom at the same time. However, the defendant can't harass the victim or threaten the victim for testifying or any other witness for that matter in the courtroom. Also, mediation could be done with a court order in place too. If the mediation was a court order to have mediation done, both defendant and victim can go and have that order of protection still in place.
Wow. What else happens at an arraignment?
Well, before I get on to that, I just want to say one more thing about orders of protection. I know it's a large topic.
I was thinking we could talk about that for a while. I find that in itself is really interesting.
It is. When people have a child together or have family court proceedings and they want to change the order of protection, that let's say that is a no contact order of protection, and they want it a no illegal order of protection, and they don't have time to go to criminal court, or they want to have the child have or the defendant have visitation rights with the child, the criminal court order of protection can be modified by a family court order of protection.
Oh, it can be. Okay.
Because actually family court is a more superior court over the local city and town courts. So if there does need to be an order of protection modified for a child and visitation, that could be an alternative to go to family court and have that petitioned there.
Oh, okay. So you don't have to wait and keep going back to the criminal court.
Right. Maybe one final thing about an order of protection that we haven't talked about yet is that a order of protection needs to be signed by the defendant. So if
that's a big part of it.
Absolutely,
yeah, wow.
Because if the defendant was given an appearance ticket to go to court and they didn't appear to court, an order of protection can't be issued, even if the victim is there wanting to have one done, because the court can't issue an order of protection that the defendant doesn't know about. So he needs to physically, he or she physically needs to sign that order of protection.
Well, that seems really sensible in the sense that then they know the defendant has truly been aware that there's an order of protection. The downside would be someone they can't find, I suppose.
Right, and then the victim would have to leave the courthouse and not knowing what he or she is going to confront on the street on the way out. Absolutely.
What else about an arraignment? Anything else you want to share?
There's a lot of things at an arraignment. Absolutely. Order of protection is just one of them. A common question that the victim has when I see them, and they ask, do they need to retain a lawyer? And if the victim does not need to retain a lawyer in criminal court, and it's actually, there's little flexibility for a private lawyer to do in criminal court, since the district attorneys and assistant district attorneys represent the people of the state of New York. So in that, the district attorney being the prosecutor, that's how the prosecutor, the DA, is actually the victim's lawyer.
And then someone like you could help the victim understand the process more and, you know, sort of speak for them and be an interpreter in some ways, right?
Absolutely. Spend time with the victim, let them feel more comfortable in the situation that they were really just thrown into, because a lot of the times the victims don't have a choice whether or not to become a victim, unfortunately. So we certainly try to be a buffer in that and make it a little bit more easier for them, rather than the busy district attorney.
I think that's great. I think it would make me feel more like kind of like a safety blanket in a way. You know, you're going into a situation that you're totally, hopefully, unfamiliar with.
Right.
So to have someone there like yourself, you know, being an interpreter and liaison, I think that would just make me feel a lot better.
Okay.
Yeah.
Well, great. Okay. Great.
Personally.
Also at arraignment, from the defendant's point of view, the defendant is given the formal charges of what he's being charged with. The judge would put in a not guilty plea for the defendant. That's an automatic thing, because the defendant would get a adjournment to retain a lawyer. The defendant would have a very little opportunity to plead guilty at a adjournment. At arraignment. That's what the adjournment is for, to retain the lawyer, so that the lawyer can inform the defendant on what the possible outcomes of the charges are against him.
And then next they go to a preliminary hearing?
Yes. If it's a felony, a preliminary hearing would be the next step at the local court after the arraignment. A preliminary hearing is actually a fact-finding decision for these felonies, because
it's the okay.
It is considered a fact-finding decision because the misdemeanor court, the local court that arraigns the individual, needs to find out if a felony was indeed committed. And if it was, they would move the defendant's case from the local court to county court where all the felonies take place
Is there always
proceed.
a preliminary hearing?
Not always. Well, a preliminary hearing is actually, like I said, a fact-finding decision where it would be actually a mini trial. The defendant typically waives their right to the preliminary hearing. So the defendant says, you're right, the evidence that is against me could be construed to be allegedly a felony, so I'm going to waive my right to the preliminary hearing and take my chances in county court. The reason why a defendant would do that is because it would look favorable upon him in front of the court in order to set bail. Because between arraignment and preliminary hearing, he or she is usually remanded in jail and behind bars for that 3 days, because it's actually 144 hours that between arraignment and preliminary hearing that the defendant needs to be in front of the preliminary hearing. So by waiving the preliminary hearing, the defendant gets a chance to get bail set, and that bail is obviously an opportunity for him to get out. Since I talked a little bit about bail and no bail, why don't I talk a little bit more about that, which usually happens at arraignment.
Okay.
The defendant and the judge makes a decision on how to release an individual at arraignment. It is either ROR, which means released on their own recognizance, and they're just set free and asked to come back at a next court date. A bail could be set in regards to a number of factors, such as flight risk and connection with the community, as well as how long they've lived in the community and how long they've been in a job. There's also release under the supervision of probation, where they would actually have to go and see a probation officer. So those are the things that typically can happen at arraignment. And then the preliminary hearing is an opportunity for the victim to be at court.
And then they might go to county court then, right?
Yes.
Okay. And what happens then?
At county court, there would be the next phase in county court is a grand jury, and the grand jury needs to see if there's enough evidence to maintain it again at a felony level.
Is there always a grand jury?
Typically, for somebody to be indicted on felony charges, yes, the grand jury needs to come back with a true bill to indict the individual.
But if it's less than a felony, if it's a misdemeanor, then there's no grand jury.
It would never go up to grand jury. It would just be disposed of at local court.
Well, when you talk about disposing of it, how are the cases disposed of?
One of two ways, of course. Either a plea bargain or trial. A plea bargain is where the district attorney and the defense attorney come to an agreement, hopefully with the support of the victim, and to dispose of a case in something less than the maximum. And then in trial, there would be a time that both the victims and police officers and everybody would testify, because the defendant didn't take a plea bargain, to find out if this defendant is indeed guilty of the crime.
So the victim does have a say in the plea bargain?
The victim does. Now, the victim can give information, and consideration can be given from the district attorney's point of view on that, and the district attorneys are very good in making the victims happy, in the sense that so the victims can get a sense of justice out of it, but not always. Sometimes a victim would want somebody to spend the rest of their life in jail for a very minor crime, and it can be vice versa, that they don't want a defendant not to spend any time in jail for a very serious crime. So again, the district attorney's allegiance is with the state of the people of New York. However, the victim, so it's not just specifically what the victim would like to see. But again, the district attorney is typically compassionate and sympathetic to the victim, and want to afford any type of feeling of security and justice that they can do.
When does a victim have a voice? It sounds like in the arraignment, if they go to the arraignment. Are they part of speaking with the district attorney,
At
giving their
times.
opinion or having a say on the impact to them of the crime?
Absolutely, at times. In regards to the most serious crimes, of course, the victims say is very, very important on the serious crimes. If the victim would want to see an individual go to jail, that would be sometimes afforded to them. But with the very least serious crimes, it's sometimes, since there's a large volume of them, they don't have a lot of face time with a district attorney as they might on more serious crimes.
What's your conclusion of this whole process?
My conclusion is kind of based on what I was saying, is that the victim has very little say, unfortunately. That's why I'm in the position that I'm in.
That's great.
That's why that there's a lot of people that would like to pay attention to victims, because the defendant are the ones who receive all the constitutional protections and rights. If you were to put it out on a scale, the defendant would have much more rights than the victim, and that would be, for the most part, the conclusion that I would like to come to.
How can people get in touch with you or the office to get help or find out more information?
If you'd like to get more information, you can call the Albany County Crime Victims Sexual Violence Center. Our phone number is area code 518-447-5500.
And they can ask for you. And what other help is there?
Well, at our
actually?
office, there are multiple of crime victims advocates. We also have a whole host of therapists for individuals who are seeking therapy based on crimes, specifically not only to sexual assault and domestic violence, but any types of crimes.
And also, in addition to your court advocacy, you can give information too about some reimbursement possibilities.
Well, right, we do fill out information for the New York State Crime Victims Board, which is an agency that reimburses victims for certain monetary compensations, like out-of-pocket medical expenses, even lost wages, time from work due to the crime. And also at our office, we do have a prevention educator who's more than willing to come to any group and speak on multitudes of information.
Great. Thank you, Matthew, so much. You've shared such great information about court advocacy, and I think it's wonderful knowing that you're out there to help people.
Okay, well, thank you for this forum to get more information out to the people.
Okay. Give Matthew a call at 518-447
5500.
5500. Okay, thank you. Bye-bye.
Bye.